There's 7 to 10 of us here who are honestly not bearing their weight. It isn't that we haven't spoken to them privately, we'll continue to do that. Some we haven't, and some we have written letters which I think I ignored. But whether or not we write to you or we talk to you, did you see me anywhere near you as you were taking your oath of office? Today, we hear you are in charge of performance. These judges are just not working. Some of you, PJs, you know yourselves, because you have called me and you have said, can you remove this judge from here? And then take them where? Home, I think, but not to another station. Are you still good for purpose? And when you're dragging the rest of us behind, and last I checked, our salaries were equal. We are all aware of the national crisis that is sexual and gender-based violence in this country. And as it has variously been highlighted, and more importantly, by the recent surge in incidents of femicide across our beloved country. The recent report by the Task Force on GBV, chaired by her leadership, the Deputy Chief Justice, retired Honorable Nancy Baraza, calls for institutional coordination, a whole of government and whole of society response to this crisis. We must play our part as the High Court, and we must play our part as the judiciary. The study showed that 55% of children in Kenya are affected by what the study describes as multidimensional poverty, and underscored the need for holistic, multi-sectoral interventions to address overlapping deprivations and promote inclusive, evidence-based policies. The theme before us also requires that we move beyond viewing justice as a purely procedural enterprise. That's not what it is. Justice must be more than procedure. It must be humane. For vulnerable women and children, the court process itself can either become a pathway to protection or an extension of the harm already suffered. A justice system that is constitutionally sound but otherwise harsh risks losing both its moral authority and its transformative promise. Your leadership in this regard is therefore very critical. Each one of you must ensure that the local legal culture of a station delivers effectively and efficiently for court users in that locale. The vulnerabilities faced by women and children are not identical across stations. Even judges are not identical. In some places, the most pressing issues may be child neglect, defilement, teenage pregnancy, trafficking, or custody disputes. In others, domestic violence, technology-facilitated abuse, economic dependency, harmful customary practices, or long travel distances to court may present the greatest barriers. When I worked,
this year's theme, Protecting Vulnerable Women and Children and Strengthening Judicial Intervention for Access to Justice, is both timely and deeply consequential as it resonates directly with the judiciary's vision of social transformation through access to justice, the STARJ. At the heart of the STARJ is a profound recognition that justice must be people-centered, inclusive, and responsive to those who are most vulnerable. Cases involving gender-based violence, child neglect, custody battles, and inheritance disputes are among the most emotionally charged matters that come before us on a daily basis. They carry with them broken families, traumatized children, and survivors seeking not just a verdict, but a restoration of dignity. As leaders within the High Court, we must therefore be deliberate in how we respond. We must strengthen victim-centered approaches within our court processes, ensure the timely and efficient resolution of cases involving vulnerable persons, deepen collaboration with stakeholders across the justice sector, and safeguard our courts as spaces that are safe, accessible, and responsive to all who seek justice. Strengthen our judicial intervention and enhance access to justice where it matters most. It is a deliberate pause for the High Court to reflect on its journey, assess how it has advanced access to justice for the vulnerable, reflect candidly on the gap between promise and practice, and to determine with urgency and resolve what must be done. I have been in office for 3 years. During those 3 years, we have had 2 bunch of judges, 20 judges, another 20 judges, and by God's grace, next week or next month, we'll get 24 judges. What Kenyans want here, these judges we are getting, is there a difference? Are we making difference for the people of Kenya?
We have supported 4 million marginalized women and girls in accessing justice. This support has been actualized through implemented initiatives, both individually and collectively, with other partners, including the judiciary. Despite significant work done, coupled with progress in our legal aid and institutional frameworks, the reality for many women and girls still remains deeply concerning. Across women and girls in Kenya continue facing barriers to access to justice in terms of accessing courts, including issues of costs, the distance, and even the stigma for gender-based violence victims and survivors. Number 2, the delays in the resolution of cases. Number 3, the challenges in enforcing court orders. Indeed, for many survivors that we've attended to of gender-based violence, and for many children in vulnerable situations, the justice system can be can feel distant, can be very intimidating, at times even out of reach. This in
knowing our country and where we've come from, to talk about women and children, we already know that they suffer historically all manner of injustice. So to talk about vulnerable women and children, you can imagine what that means. And therefore, this conference underscores the critical role of the judiciary in safeguarding the rights and dignity of the vulnerable. The judiciary and the High Court in this respect plays a pivotal role in translating these rights into reality. Our courts must remain accessible, responsive, and protective, recognizing that every decision can either bolster or erode public confidence in the justice system.